It is a good morning when you fight for justice. I'm Tina Longo. I'm the Chief Attorney of the Legal Aid Society's Criminal Defense Practice, and I have been a public defender in New York City my entire legal career, over 23 years. Before we begin this morning, it's really important for us to pause and take a moment of silence. We have lost many lives in our prisons and in our unjust criminal system. So I want to honor this space by naming Robert Brooks, Jonathan Grant, Anthony Douglas, Franklin Dominguez, and a 22-year-old who just died yesterday, Messiah Natwi. And of course, we could not be here today, and this law would not be on the books without Kalief Browder. Name him today. Kalief Browder. I cannot believe we are here yet again, one more year, trying to fight to hold back a law that everybody stood behind. Everybody said it was the right move. Everybody named it for what it was, undoing a blindfold off of the accused who deserve the right to see their evidence. We're here today because this alliance is holding on to the justice to prevent the rollbacks of Kalief's law, New York City's discovery law, a law that brought fairness and due process to those prosecuted throughout our state by simply providing the accused and their defense counsel timely evidence. Let's be clear, this law did not create new evidence. It simply required the prosecutor to turn over evidence that was already there. We're here because the district attorneys, particularly the district attorneys in New York City, and law enforcement like NYPD, and now our governor, are planning to roll back and gut this law. Let's be clear, it's not a tweak. It is a full rollback.
That ain't right.
That ain't right. This isn't new. The DAs and police never wanted discovery reform. And since its inception in 2019, have been up here trying to roll it back year after year. Now, they rely on lies about cases being dismissed for technicalities. Now, they are pathetically saying that this law somehow places victims of domestic violence in harm's way. It is a lie. They will distort data to try to make it seem as though discovery is preventing felony cases from being adjudicated. It's a lie. It's a lie. Today, our speakers and this alliance is here to say, enough is enough. I want to turn it over to our first speaker, Derek Hamilton.
The major single witness against me came before the court and said that I had shot her boyfriend, and I couldn't understand why. There was a document in the police files that when she first went to the scene, she told the cops she did not see this crime, that she was around the corner at a store when the murder happened. That document was turned over on the eve of trial under an alias name. And when my lawyer asked the prosecutor, then Ann Gutman, was this the same witness, they said no. My lawyer trusted the prosecutor, and it cost me 21 years in prison.
That ain't right. That ain't right.
This law has went into effect because we know we can't trust prosecutors. That prosecutors has hidden evidence, and 40% of the cases on the National Register of Exoneration, the wrongful conviction occurred because the prosecutor had evidence that could prove a person innocent and kept it. How can we roll back a law that keeps innocent people out of prison? William Blackstone once said that they'd rather let 10 guilty people go than to convict one innocent person. Today, prosecutors have said, forget the innocent at all costs. Forget giving them discovery that can prove that they're innocent. Let's send everybody to jail despite the discovery law. Just last August in Brooklyn, Arvell Marshall was released after spending 16 years in prison. And during the trial, he said to the judge and to the prosecutor, there's a video that shows who the real murderers were. And he kept begging and yelling for this video. They kicked him out of the courtroom. 16 years later, they looked at the video and it showed who the true killers were. It wasn't him. This is what the prosecutors do time and time again with discovery. They hide it, they keep it from defense counsel, and now they're saying, let defense counsel guess. Let them be clairvoyant. Let them not know what the evidence is. We can't roll back discovery, because if we do so, innocent men and women will go to jail. Say hell no to the rollback on discovery. Thank you.
Hello, my name is Rebecca Garrard, and I am the Interim Co-Executive Director of Citizen Action of New York. Our organization was a leader in the fight for discovery and speedy trial reform 6 years ago. And it is shameful that we stand here today needing to protect these basic rights. Make no mistake, the proposals in the governor's budget are not tweaks to the system. They are a complete dismantling of the safeguards passed in 2019.
That ain't right.
Not right.
Not right.
These changes would allow DAs to choose which evidence is relevant, including evidence that could prove the innocence of an individual who is charged, and places no requirements, only recommendations on what it is that should be shared. The DAs have painted a picture of a rash of dismissals related to these laws. I want to be really explicit here. That narrative is a lie.
A lie.
Under current laws, DAs can obtain adjournments and extensions for a whole host of reasons, including witness availability. And the only increase in dismissals that actual data supports are related to misdemeanor charges in a specific reason. This is not due to a policy problem. It is the direct result of a rogue and non-compliant NYPD. Tens of millions of dollars have been allocated to ensure that DAs and police departments can use systems that create access to evidence records in real time. This has not occurred for one reason, and that one reason alone is that the NYPD has refused this level of transparency. Instead of the DAs asking the state to change requirements, they should be demanding that the NYPD held accountable to providing evidence in real time related to their investigations. Withholding evidence and attempting to force guilty pleas due to desperation, not facts, is not public safety.
At all.
Let us never forget the case that brought attention to our state's previous practices. A teenager was snatched up by the NYPD, thrown in a cage for 3 years without the chance to see the evidence against him and prove his innocence in court over a backpack. 3 years that ultimately cost this young man his life. The law we fight to protect today, Kalief's law, was meant to ensure that no other person or family should suffer the same tragedy Kalief Browder did.
Right.
We call on the legislature today to stand up and say that withholding evidence and leaving people charged indefinitely is not justice. It is an abuse of power being led by an NYPD that is known for corruption at the highest levels. Right. At a moment when civil and human rights are under unprecedented attack, it is unconscionable that our state would participate in furthering this instead of holding the NYPD accountable to the most basic rights. There must be no rollbacks to Kalief's law, not now and not ever.
No rollback.
It is sickening that every year since we passed speedy trial bail reform and discovery reform laws that this governor chips away at these reforms. This year, she's trying to take a pickaxe to discovery laws. So here we go again, folks. We wish to remind everyone again the hard-fought win of discovery reform, how having all of the information before deciding to plea is essential to the fair administration of justice. The system always has racial disparities in it, where black and brown people are often forced to take plea deals without all the information. Kalief's law made some progress in balancing those scales of justice. So I ask you, why would we want to weaken the law? I know during the budget process, we try to cram in a lot of policy stuff so that the Assembly and the Senate will approve policies they might not otherwise approve for fear of holding up the budget. Let's get this bill out of the budget process and air it out more publicly after the budget is done. If we want to do anything in the budget, then let's concentrate on directing taxpayer dollars to essential community-based services to protect the least of us, and direct those funds to communities who for too long have been without resources. This is how you deal with the real cause of recidivism, instead of thinking that rolling back discovery laws is going to solve your problem. So let us also be clear that open and full discovery helps prevent wrongful convictions. They have nothing to do with preventing recidivism. Finally, we are people of faith, and we always believe that we have to stop using incarceration as the default response to violence and conditions of poverty. A more Christian response focuses on rehabilitation and care, not retribution and incarceration. Let's stop this law from passing. Protect discovery reform.
So I want to thank all the members of the Alliance to Protect Kalief's Law for being here today to remind us that when discovery laws are whack, it's not only the process that suffers, it's the people in our communities who are hurt. That is why we are never going back to the days where discovery can be weaponized by the prosecution to compel the innocent to plead guilty, the honest to lie, and the free to be thrown into solitary confinement. I also represent a district where Yusef Salam is my council member. Kalief Browder's passing brings tears to my eyes, even today, and it always will, because the prosecutorial and correctional system destroyed the life and the spirit of yet another innocent black child. Never again. Our landmark and fair pretrial discovery laws were enacted simply because the system was unfair, inequitable, and abusive. Any attempt to roll back these reforms is simply a shameful license to kill. You can count on myself and my colleagues to excise this poisonous language from the budget. We are fighting for that. We know what it means. We fought too hard, and we know the cost We know it firsthand and up front, sadly. So we're not going back.
Good morning. So not only do I represent the 168 private attorneys in Erie County representing indigent clients in criminal matters across Erie County on my 18B panel, I represent the nearly 2,000 criminal defense attorneys, both public and private, across the state of New York, and we are unanimous. Our discovery laws must stay intact. A repeal of Section 245 would be damaging beyond measure. You've been hearing this law is broken, and it needs to be tweaked in order to work more effectively. And you've heard New York City DAs, most notably Bronx DA Darcel Clark, claim that we need to level the playing field to make things more fair for prosecutors. Think about that, more fair for prosecutors. You may have heard that cases are being dismissed left and right across New York State, which means the law is too difficult for prosecutors to deal with and that change is necessary. These are myths, they're lies. Let me spit some facts at you. Let's go. First, dismissal rates. With the exception of New York City misdemeanor cases, cases across New York State are not being dismissed for the failure of prosecutors to adhere to the mandates of the law. Upstate, prosecutors are making the system work. And how do we know? In comparing dismissal data pre-reform in 2019 with data from 2024, it's clear the law is working. In Erie County, there are 1% less dismissals. In Nassau County, 5% less. Monroe County, 6%. Suffolk County, 1.5% less. And if you look at the indicted felonies across the state, the cases the DAs really care about, the dismissal percentages are virtually identical between 2019 and 2024, which means on the cases they really want to prosecute, they have no problem complying with the mandates of the law. Diligent DAs do not have cases dismissed under this statute. So when the New York City DAs tell you that they can't comply, that it's too difficult, it is a tremendous all-time self-own. You're telling me the most well-resourced, well-staffed, and most talented prosecutors' offices in the state can't do what the DAs in Rochester and Buffalo can do?
Stop embarrassing yourself.
Boy, that's quite an embarrassing indictment of the management of your offices, the duty to justice, ladies and gentlemen, and their oaths. Second, you may have heard the DAs claim that defense counsel are lying in wait. Lying in wait. What does that even mean? DAs are claiming that defense counsels are gaming the system, waiting until the expiration of speedy trial times to communicate missing items of discovery that they know they haven't received, and then moving to dismiss cases when they haven't received it. And it just isn't true. And how do I know this? Because in 2022, the DAs complained of exactly the same thing. And we fixed the law. Defense counsel like Tina Luongo sat in a room with the DAs and they crafted the soon as practicable standard. Soon as practicable. Defense counsel must object as soon as practicable after learning of materials they don't have. And if they fail to do that, if they lie in wait, looking to spring a trap, they get no dismissal under CPL 3030. They get no sanctions under the discovery law. They get nothing. They get nothing. Finally, you've heard this is a tweak, but plenty of people have said it today, that it doesn't change the spirit of the law. Albany DA Lee Kindlin, a former defense attorney himself, shamefully, recently claimed in an op-ed that the governor's changes don't alter a prosecutor's core responsibility in any material way. That these are common sense changes. You know, with all due respect to DA Kindlin, he is stunningly, hilariously wrong. The governor's proposal completely disincentivizes the DA to cooperate with law enforcement to obtain critical evidence and share it with defense counsel. It gives the DA the authority to decide what's relevant, and then only to turn over that material to defense counsel. By allowing DAs to declare ready for trial and stop the speedy trial clock, providing only materials in their actual possession, it eviscerates any accountability for failing to completely and timely disclose discovery. In short, it returns us to the pre-2019s of days of blindfold pleas and trial by ambush. And further, it's going to result in substantial delays in proceedings while defense counsel endlessly litigates the difference between what we believe is relevant and what the DAs believe is relevant. It's going to result in increased incarceration time for those languishing in jail pre-trial due to this litigation, and the DA's ability to stop the speedy trial clock shortly after arraignment. It's going to result in pleas to charges with less than full information because the DAs have no incentive to provide it. And ultimately, it's going to result in wrongful convictions. Those same convictions that saw New York City pay out over $200 million to wrongfully convicted and incarcerated clients in the years before this law went into effect. Outstanding use of tax dollars, New York City DAs. In short, the level playing field that DA Clark wants so badly to return to is the one that caused Kalief Browder to unjustifiably languish in jail for nearly 3 years, on her watch, by the way. And that's the system that ultimately caused his death. This is what they want. So it's amazing, although unsurprising, that after 5 years, the governor and DAs are still seeking to roll back this fair, equitable, just, and common sense statute. In a state where the cost of living continues to skyrocket, where safe, affordable housing is an aspiration rather than a right, where our incarcerated brothers and sisters live daily in a hell of dangerous conditions due to gross mismanagement by docs, where the mayor of our largest city is bought and paid for by a corrupt federal administration, and where the rule of law is under attack daily by that same corrupt administration. This is what our governor and DAs have made a signature priority of this year's budget. Yes. Destroying one of the most successful criminal legal system reforms of the last century plus. Don't let them get away with it. Tell them loud and clear, enough is enough. The law works. It's staying intact. We're not going back. Start making it work, NYPD. Start making it work, New York City DAs. Justice is too important. Make sure Kalief Browder didn't die for nothing. You must omit Part B. Thank you.
I grew up in the era of stop and frisk. We didn't call it stop and frisk. We just called them the hop out boys, right? They just hopped out on you, you lifted your shirt, did a little 360, and they drove on their way. I grew up in this era of intense policing. I felt for Kalief when this happened. But I want to take it a step back to say a few things about Kalief Browder. Because Kalief Browder, like we said, was accused of stealing a book bag. Spent 3 years on Rikers Island, 2 in solitary confinement. But the part I want to bring up more specifically is Kalief made 31 appearances at the Bronx Superior County Courthouse. And 31 times Kalief Browder was sent back to Rikers Island. Because the evidence, I don't want to call it discovery, because the evidence against him wasn't ready for trial. And 6 of those cases, 6 of those times, he stood in front of the Superior Court judge in the Bronx. That judge was Superior Court Judge Darcel Clark herself. The Bronx District Attorney, exactly. The Bronx District Attorney, who is now the face of trying to roll back Kalief's law. I didn't come up here to talk today. I came up here to support everybody. But hearing my brother right there speak, made me realize, no, there's a little bit more that people need to realize. This isn't an accident. Darcel Clark knew what she was doing. And I remember this really well because on February 17th, Kalief went in front of Darcel Clark. The prosecutor was on vacation and she sent him back to Rikers Island. On February 18th, he made an attempt on his life. And I remember this because my birthday is February 18th. So that's something that really, really sticks with me. I was celebrating my birthday, and Kalief was trying to take his life. That's one of the things, when I started to do this work, when I started to do this research, I said, oh, hell no. We cannot go backwards. We cannot, as I was told, put the blindfold on. So that's all I came up here to say really quick. Thank y'all for coming up. Thank you for the work. And let's keep doing this, y'all.
I want to remind everybody, as this coalition has been reminding the state for the last several weeks, that we passed these laws for a reason. That Kalief Browder's death was something that could have been prevented by the reforms that we have now put in place and have been in place for years now. These laws have ensured that New Yorkers coming up against the justice system have an opportunity, a real opportunity of fairness, a real opportunity of justice. Because I know that as a family member of someone who has been a victim of a crime, I don't want the wrong person going to jail for something that they did not do. Let alone for somebody to be held for an extended period of time, not knowing what is being levied against them, not knowing what the prosecution has in its control that we could then find and see would strengthen a defense to a defendant. These laws, these reforms, we keep coming back to them and forgetting why they were passed in the first place. How many countless New Yorkers are not languishing in jails because of these reforms? How many lives have been saved because of these reforms? Now, I know the district attorneys and others are presenting some story of cases being thrown out by the thousands. But I just want to say, is it not worth it to make sure that somebody is not getting incarcerated for a crime they did not do? Is it not worth it to ensure that the constitutional protections afforded to them are upheld? Is it not worth it to ensure that justice is truly served for all New Yorkers who are impacted, who come in contact with our justice system? The New York State Conference of the NAACP has been working for 100 years within the broader organization to ensure that New York is a fairer and more just place. We are fortunate to stand here with defenders and advocates and folks who truly want to ensure that justice is served. And we will never relinquish that commitment to justice. So we're going to stand with these folks. We're going to stand with the defenders. We're going to stand with every organization that has that shared commitment to justice. We do not want to go backwards. We refuse to go backwards. Now, you've probably heard me say before, I don't believe law is a set it and forget it game. But changes must be ones that are informed by the people who are doing the work. These people, they're doing the work. They've been doing the work for a long time. Come talk to us. Come talk to us if you want to know how to improve New York's criminal justice system. Come talk to those closest to the issue. Come talk to those who are impacted by that system every day if you want to improve the system. We don't really want to hear anything else. We are urging our state elected officials to reject this proposal. We are urging the governor and the executive chamber to come have a conversation about reforms that would be helpful and not ones that'll send us back. We got rid of the blindfold law. That doesn't exist anymore. We're not going backwards. Thank you.
We won't go back. We won't go back. We won't go back. We won't go back. We won't.